All rise.
Further hearing in the appeal of AM Somalia.
My Lords, good morning. There are three topics I would like to deal with in rounding off my submissions on behalf of SA and AW in the context of AM Somalia number 1, and of course all of my submissions will in due course be adopted in AM number 2, which has its own discrete Article 14 issue. The first of the three topics is to step back and look at what's happened in the case law in this area. And what's happened has involved three steps. Step 1 was that the rule, reflecting the wording we saw in section 3, in particular in the context of spouses, but the immigration rule picking up on that phrasing, maintenance of themselves without recourse to public funds, was given a clear and settled meaning. And that was Ahmed Ali number 1, Ahmed Ali, Mr. Justice Andrew Collins. And so it stood for 7.5 years. The straightforward purpose, which at step 1, that wording had been held to reflect, was the purpose which Mr. Justice Collins identified in Ahmed Ali. Ahmed Ali is bundle 6, tab 53, and just for your notes, he identifies it at page 96, letter F. The adjudicator had identified the straightforward purpose of the rule, which is Ahmed Ali 93 at letter C. The purpose is to ensure no recourse to public funds. As Mr. Justice Collins put it, the Secretary of State has nowhere disputed that the intention behind these particular rules was, as the adjudicator stated, this is 96 letter F, namely to ensure the admission of the family should not result in any recourse to public funds. And it was a straightforward interpretation, and it was based on what we might call the Alexander technique, the sensible...
I'm sorry to interrupt you. You're moving rather
96.
fast. You're referring to 93, which is...
93 is the adjudicator, my lord.
I was trying to find the bit where...
It's just above letter C.
Yes. Right.
Does my lord have it in
I
the
do.
quotation?
Yes. So it's 93C. And then going on to 96... Did you
96 F.
Yes.
I was reading the sentence that begins
Thus.
second word on the line.
Sorry, what tab number again? I've got the wrong.
I'm in tab 53 of bundle 6.
Okay.
Tab 53
Yeah, I got it.
in bundle 6. I apologise, it's my fault. It's page 93, my lords, in the report, just above letter C,
Yes.
is the adjudicator.
Am I going... No, I haven't got the page number.
Is my lord in AM number 2, or AM number 1 in the authorities?
AM number 2.
We need AM number 1, my lord.
Oh, goodness me, I didn't realise we had lots of different authorities.
There are some additional authorities in the other appeal.
Yeah, okay. Well, anyhow, I'll find it eventually, yeah.
Does my lord have in AM number 1, bundle
Yeah.
6, tab
Yeah.
53?
Yeah, I got it.
And again, I apologise, it was page 93, just above letter C, my lord. Do my lords have that? The
Yeah,
purpose
yeah.
behind this rule, and then 96 at letter F,
Yep.
the intention behind these particular rules, as the adjudicator stated.
Yes.
And if you turn over, I'm trying to avoid passages I know you've already been read, but at 102C, just to remind my lords, that if you look at letter C on page 102, this was an approach recognising they're not to be construed as if statutory provisions, but sensibly in accordance with their natural meaning and purpose. And then citation of the Alexander case.
Yes.
And that's what then leads at letter G on that page to what I know you've seen.
Yes, I mean, it's a contrast with the other rules and between F and
There's
G.
the contrast with the other rules, and there's no reason in principle why the family should be kept apart when the purpose is being satisfied. The purpose is quite clearly met. The natural meaning of the language used is consistent with that construction. And we saw the Pizza Uncle case, Mahmood, as a good working example of this approach. And that was step one in the case law, an established meaning. Step two concerned the child rule that we saw yesterday, Rule 297, because that had been amended following subsequent to this decision. The amendment of that rule had brought in the phrase by the parent in the context of accommodation and maintenance, and you've seen that. And that amendment was to come into force on the 2nd of October 2000, a date which we would suggest is of significance. And step two was that the entry clearance officer succeeded in persuading first the tribunal and then it being upheld by the Court of Appeal, this was MW Liberia, that deliberate act of amending that rule had adjusted the meaning in relation to its application. That argument was accepted, and it was said to relate to child protection, that rule had been amended in that way. And you'll recall from MW Liberia in the Court of Appeal, Lord Justice Tuckey, it was paragraph 10, and we don't need to turn it back, you were read it yesterday, it's bundle 5 tab 45. Paragraph 10 proceeded on the basis that Mr. Justice Collins was right in Amin Ali in relation to the wording and the rule with which he was concerned. The analysis in relation to the child proceeded on a deliberate act of changing the wording for some reason. Step three in the way that the case law has developed in this area is that third-party support having been excluded under the child rule, so holds MW, the exclusion then spreads across the rules to the spouse rule in the context of maintenance, and that, of course, is the present case. The Court of Appeal saying, well, it doesn't really make a lot of sense for the rules to have different meanings. If by the parent brings in an exclusion of third-party support, then themselves has an exclusion of third-party support, with strong reliance being placed on the role of the sponsor. You can have an undertaking to underwrite the lack of recourse to public funds. But as I explained yesterday, the logic of that must extend to the Section 3 simpliciter situation, where you've simply got a condition on the individual. There's no sponsor at all. If you've got leave to enter, which is conditional under Section 3, on the basis that you will maintain yourself without recourse to public funds. So the sponsor goes as being the underpinning of this approach. But then the exclusion spreads further to Lord Panic's rule, on which he will be making submissions and I won't. 317, the dependent relative. Even though one doesn't have the by the parent or the themselves
That's
formulation.
Little 3, is it?
Little 3.
It's 4.
It's. I'm sorry. It's 317. It's not the dependency provision. It's the.
I see. Oh yes, it's 3174.
It's 4 and
4A.
4A.
Both 4 and 4.
4 and
4 is
4A.
for accommodation.
4 is accommodation. 4A is maintenance.
Yes, thank you. Yes.
So one sees the exclusion spreading now that the door is open, and it spreads even further. So, for example, Immigration Rule 95, the working holiday maker, and the case that,
Where's that?
that deals with that. I mentioned that provision. It's on page 2836. 2836. The rules, as you know, are in tab 8 of bundle 1.
Yes.
It's an example of a rule that reflects the statute. And Roman 5 is the provision that does so. And as this exclusion of third-party support has spread, so in a case which we don't need to turn up, but I'll give you it, if I may, for your note, called KS India.
What's it called?
KS India, Bundle 5, tab 41. Now that the die is cast in relation to the exclusion of third-party support is being excluded there as well. And moreover, in the context of that rule, with a strong dissent from Lord Justice Sedley, it's extended to accommodation, because accommodation and maintenance are together.
They're in the same rule.
In the same rule.
Yeah.
Sorry, when you say dissent from Lord Justice Sedley, was that simply on accommodation, or
Yes.
did he dissent?
He did. In relation to maintenance, the position at the level of the Court of Appeal, as Lord Justice Laws in the judgment below explained, is that the die has been cast by binding Court of Appeal authority.
And
So that's the way in which all of this has spread.
you say we don't need to look at KS India, is that right? We don't need to see what Lord Justice Sedley said, do we?
Well, of course, if my Lords wish to look at KS, it's tab 41 at Bundle 5. I hope it makes good what I have explained. It might make sense to start with the dissent, since his was the first judgment, Lord Justice Sedley.
This is very recent.
And he explains the issue at paragraph 1. Then at paragraph 6, the factual matrix was third-party support from family members.
So it's an accommodation case, pure and simple.
It is.
Yes, I see. I hadn't
It
realised.
is, yes. But what the Court of Appeal does, all of them, is cite MW
Yes.
and cite AN. See paragraph 20 in the judgment of Lord Justice Sedley. And based on that reasoning, binding as it was, with the same language and the concept of sponsorship that had been relied on in those two decisions, the maintenance issue is decided adversely to the individual. Binding authority is held to compel it. But Lord Justice Sedley explains at paragraph 30 he's not constrained in relation to accommodation. Indeed, Lord Justice Laws in the judgment below in this case referred to the different position that has been held previously to apply to accommodation for spouses. It's paragraph 30. And he refers to the holding of the tribunal and the logic. It's correct, a foreign national who wishes to come here cannot rely on accommodation provided by family or friends any more than meals or transport provided by them. He has to have the means to pay his own way in all these respects, even if it's plain they're going to be provided for him. And then counsel has not been able to explain what policy this enacts. And then his conclusions, I'm not going to read them out, I commend them to you. You can see at paragraph 37 onwards. But he too has noted at 34 that other rules are explicit.
Yes.
The other two judges in that case, Lord Justice Wall and Lord Justice Pill, disagree and say really the logic has to apply both to maintenance and to accommodation. I ask you to note with regret at paragraph 47 in the judgment of Lord Justice Wall not being in a position to apply a purposive and humanitarian construction. But he goes on to describe MW in the Court of Appeal, that's paragraph 56.
So why do the majority say they're driven on accommodation when accommodation was held in our cases not to be subject to this approach?
If you look, my lord, at paragraph 60, it's
1-6?
No, 60.
60, yes.
It's because of this word himself.
Paragraph 57.
Yes, and 85, I think.
I prefer to rest, certainly 56 he starts with MW Liberia, 57 the precarious nature that Lord Justice Tuckey had described. In that case, the third party support doesn't have the sponsor's undertaking. And then the idea of consistency across the rules is paragraph 59. But ultimately, as he says, I prefer to rest my decision on the plain meaning of the words, and it's the words maintain and accommodate himself. That means self-sufficient. Nothing to stop him obtaining free board and lodging from relatives and friends, but the essential requirement remains. He must show that whatever arrangements he makes with relatives and friends, he is nonetheless, and without that support, able to maintain and accommodate himself. And then for good measure at 66, towards the bottom of that page, 5 lines up, he would have preferred Lord Justice Sedley's interpretation. And Lord Justice Pill agrees with Lord Justice Wall, having himself cited the 2 Court of Appeal cases, the child case, paragraph 74 of MW, and our case, the spouse case, AM, number 1, at 76. The same nub at paragraph 85, the applicant must be able to maintain and accommodate himself, just as the parties, that's the spouses, must be able to maintain themselves. So now that the Court of Appeal in our case, AM number 1, has said that themselves is the same as by the parent, in the child rule, third party support is out, and it's out for everyone. Now, on that basis, it must also be out in my section 3 example, which, as I've already submitted, doesn't involve a sponsor. And that's been step 3. But the die has been cast by the decision in the children case of MW. And Lord Justice Laws in our case explain that at paragraph 61. Binding Court of Appeal authority, paragraph 61, following MW Liberia, and subject only to reconsideration in their lordship's house. It is fair to say that it is a development in the authorities which has caused concern. We've just seen it in the judgment of Lord Justice Wall. We see it in the dissent of Lord Justice Carnworth. He felt driven in relation to the spouse rule, but dissented in relation to the dependent relative rule, and expressed at paragraph 103 what he considered to be an artificiality, which led to a sense of regret. And if I may respectfully also point out that, as my Lord Collins will recall, he had expressed a similar regret in MW itself at paragraph 20. But that's the way the case is developed. Firstly, the entry clearance officer makes a distinction for the child case because it's been amended, but the settled underlying meaning remains. Having made the distinction, the entry clearance officer in the later cases then denies the distinction. Having got the door open in relation to the children provision, which is treated as different, the argument then changes completely. Well, if that's right, there can't really be a distinction, therefore it must apply to everything. And my lords, appreciate we have 2 arguments. The first is that with respect, the law had taken a wrong turning in MW Liberia. That's our submission. because the deliberate act of amending that rule on the 2nd of October 2000 makes perfect sense when viewed from the point of view of child protection and ensuring responsibility for the child, so that when you come to join your parents, you are coming to join them in a context where you will be with them together and they will have responsibility for you, including your maintenance. But it doesn't, we suggest, drive the conclusion that that question of who carries with it an exclusion as to how. Our second argument, and this is developed in detail in the printed case, is that in any event, having established a different approach to the child rule because of an act of amendment, that ought not to drive a conclusion in relation to the spouse rule, which had been the subject of a settled interpretation that made perfect sense and was never amended.
Yes.
And that's the alternative argument, my Lord, see the logic of it, and it's all set out. I don't need to go through it. It is deeply ironic as well as troubling, we would suggest. Firstly, to adopt a distinction as the platform for a difference in interpretation and application, and then also seek to later to deny it. That really is having it both ways. We also say it is deeply unattractive to suggest that all of this is done for protection purposes, to reinforce that the family unit will really be the cohesive parent and child, dependent relative, spouses living together, that this exclusion of third-party support reinforces that, we would suggest is in fact a grotesque submission, because the logic of it is that you can come, you can be together, you can protect the public purse, you can prove that there will be no recourse to public funds. But because it involves assistance from a third party, you don't get to be together in the United Kingdom at all. That's the first topic. The second topic of my three is to deal with the question of what, under the rules as interpreted by the Court of Appeal, is permitted. Third-party support is being said to be excluded, but what can you have? And let's take Rule 281. Well, firstly, you can have the use of existing public funds, providing there is no additional recourse to public funds. If they need to share that which the government will be providing, that can be relied on. My lords have seen that. That's been expressly articulated in the rules. I think it's Rule 6A.
Can you just... I'm not quite sure where I get my bearings on this particular proposition. The phrase is without recourse to public funds, yes. But you say that means additional.
It means additional.
But where is can you remind me?
Well, it comes from two places. Yeah. Firstly, I would respectfully suggest it comes from the rules as they stood in any event, because again, the straightforward purpose is that the act of joining and being here in this country will not be to the detriment of the public purse. That's the straightforward meaning of without recourse to public funds. It means without any additional recourse to public funds than would arise on the part of the sponsor in any event. But it's been clarified expressly in the rules, in Rule 6A on page 2793.
Sorry, yes, we saw that yesterday.
We saw it yesterday.
Yes, thank you.
So you can adjust your arrangements as the sponsor to make available your existing disability living allowance. And you saw a case in which that had occurred. Secondly, You can, for example, have employment. Wages from your employer that you need to maintain yourself is something that can be relied on.
And presumably self-employed income too.
Certainly. But employment, which could be from your uncle in his pizza business, is something that's permissible. Now, there's no underwriting undertaking under the rules from the employer. And there's absolutely no reason to suggest that it will inevitably be more precarious for someone to be relying on a close family member who is committed to support them than it is precarious for them to be relying on an employment relationship. Indeed, one might think it would be likely to be less precarious if one has demonstrated by reference to a close family member that they will provide the maintenance. The third thing which on the authorities one can rely on is help with accommodation. And I mentioned yesterday, Lord Justice Laws acknowledged the existing line of authorities, certainly didn't overturn them. It was paragraphs 45 and then 61. So, for example, at the level of the tribunal, AB and Pakistan was bundle 6, tab 55. That's the house provided for you by the cousin. And that's permissible. But at the level of the Court of Appeal, may I give you one example, which is MK Somalia, bundle 5, tab 44. That was in fact the case about using disability living allowance. But that was a case which on its facts involved living in the same house as the sister. MK Somalia was bundle 5, tab 44. And it might just be worth a couple of minutes to turn back to that, bundle 5, tab 44. The context for the application of the spouse provision is that you're living with other family members. You see that in paragraph 1 in the judgment of Lord Justice Pill, in the quotation at little paragraph 2. The two sisters live together in the United Kingdom. They both are people with disabilities who require mutual care. But that's not excluded by 281. So there are two examples. Please, if you just keep this case open for a moment longer, I'd like to show you paragraph 19. Because in the context of the availability of DLA, disability living allowance, Lord Justice Sedley explains at the end of paragraph 19 that DLA can be used. It's no different from a salary from a job. The sponsor chooses to bank it or spend it on something else. She's doing nothing unlawful or improper, for it's still her money. And then this, so too if a family member or friend provides the necessary care and help without payment. So this is the next category that you can have. You can have help from a third party with a care function that would otherwise need to be paid for.
So which paragraph 19?
Paragraph 19, the end of paragraph 19 in the judgment of Lord Justice Sedley. So you can liberate your disability living allowance to use for your arriving spouse by saving yourself care costs where a third party, family member or friend, is going to provide that care and help without payment. So another example, just like accommodation, where a third party can save you money, whether it's rent on where you live, or whether it's costs that you would otherwise incur.
So you could put it this way, could you, looking at little 5 in Rule 281, the individual will say, yes, I can maintain myself. There is a DLA which I receive. I don't actually need to use it all because my sister is actually providing me with day-to-day help.
Exactly so. And one could do the same with rent. The starting point is that I'm going to struggle to pay my rent and to pay for maintenance of me and my spouse. But here's what we're going to do. My sister's bought a house for us to move into. That's going to save me the rent and mean that I can pay for the maintenance. Or I'm already living with my sister. The final category of third-party assistance that one can have, as is contemplated under the law as it stands, are formal arrangements, and the examples that are given are deeds and orders, where one can demonstrate under some formal arrangement that payment will be coming, albeit from a third party. The references for that are in MW Liberia, which was bundle 5 tab 45, at paragraph 14, and in our case, in the Judgment of Lord Justice Laws, at paragraph 60. What all of those examples show is that the fundamental straightforward purpose is intact in all of them. You've protected the public purse. There's going to be no recourse to public funds. What they entirely undermine is the suggestion that that is explicable by reference to an undertaking under the rules. You wouldn't have an undertaking from the employer or the sister or the cousin or the person who said they're going to help with the care.
There is a hint in paragraph 14 you've referred to in MW Liberia that the reason why Lord Justice Tuckey was inclined to think that a deed of covenant or a court order would be all right is because there was it could be shown that the legal obligation to pay was there and therefore was likely to be met.
Yes,
so that there is a hint that you're looking for something that is can be relied upon.
Quite so. And the function of all of this is to be able to demonstrate.
So you're saying, are
that you can
question of fact in each case?
Of course. And the premise for the legal argument that you're hearing has to be that the individual can demonstrate that there will be maintenance without recourse to public funds. That's the premise. The only question is, in a case in which that can be shown, is it nevertheless a disqualifying feature where that satisfaction has arisen from third-party help? We, all of us, entirely accept that the individual has to show, as the rules plainly require, that there will be no recourse to public funds. And that is the true function and purpose. But these examples I've given are inconsistent with the idea that it's all driven by an underwriting undertaking, because you wouldn't have one from the employer and you wouldn't have one from the aunt. These examples are also inconsistent with the suggestion that there is something inherently or inevitably precarious about that which a third party does. If that were so, it would be true for the aunt who said that they're going to do the caring function that's going to liberate the saving. It will be true of the person who has said they're going to provide the accommodation. It will be true in respect of all of these examples.
Well, not in the case of the deed of covenant or court order. as Lord Justice Tucky saw it.
Yes, but the fact that these examples are all permissible, and I've explained the rationale that unites them, is inconsistent with a unifying rationale based on precariousness of that which a third party does.
What's the rationale, Mr. Fordham, in respect of those of independent means, that they should be able to demonstrate that they don't need any assistance from any other person?
In relation to the other provisions, they are all concerned with individuals who are coming here of their own right to be here. They're not coming here to be united with family.
And they all appreciate that, but I just asked for the rationale of that requirement.
The rationale of these requirements is that an additional value is needed in all of those situations. It needs more than that you're not going to have recourse to public funds. And in the case of the retired person of independent means, the rule has made explicit that that individual will be maintaining themselves from their own resources and with no assistance from any other person.
Rule number?
It's Rule 263 that my Lord Brand is putting to me, and it's right. Top.
I mean, I of course see the force of the contrast, but I mean, this is a different point, and I just wonder if what you're now telling us is consistent with that. I mean, there must be some value in having just such a requirement. You say it's notably absent here, fine. But you're now saying there's no point in it anyway, and all I'm saying is, well, that can't be right, can it? Otherwise, why would they do it for?
I'm not submitting that there can never be a point in it. That would be, as you point out to me, that would be inconsistent with the fact that it's expressly provided for in 263. The same goes for the writer. The writer has to be somebody who is going to be here having got a track record of being able to support themselves by what they can make as a writer. And that is carried through to the future. They've got to show that they will continue to be able to have a viable economic lifestyle as an artist or writer. But the point I'm addressing is whether there can be said to be a unifying rationale in the light of the examples that I've given, where the rationale is either that you need the underwriting guarantee of a sponsor to give entry clearance to the arriving spouse or family member, and that doesn't work, or that there is something so precarious about third-party acts that they should be excluded and only the sponsor should be counted, and that doesn't work. And that's the point that I'm addressing by illustrating where the logic takes you. But I would accept that an additional built-in requirement is included in 263, but in that very different context, that you're coming here solo, and you're coming here because you're a wealthy retired person. We will let you do that, but we require more of you in that context.
Why do you say he's coming solo?
Because the person...
Coming solo, but he may have dependents.
Well, he's not in the rule to join a dependent relative.
No, but 3 is envisaging. Isn't it that 3 is envisaging him maintaining and accommodating himself and any dependents in the UK? And that's where this business about from his own resources with no assistance comes in.
Certainly, that will at least include the dependents that he brings with him when he comes to the United Kingdom. It's not framed in terms of joining anybody.
No.
There are yet different requirements for visitors and students, aren't there? In 41(6) and 56(k)(7).
My Lord mentions 46.
41(6) on page 2807 and 56(k)(7) on 2814.
Yes.
Where it's made explicit that relatives and friends can supply the maintenance and accommodation.
Yes.
Yeah.
Yes. I again would respectfully contrast those provisions with those ones we are concerned with.
Probably means
Which
we
deal
need a schedule of all the
Yes.
references.
What was the second one? 41(6) and
56K, wasn't it?
56K.
Those are almost random.
And it's little 7.
One can see different policies at play where, for example, you are excluding somebody from taking up employment.
Yeah.
Where, for example, you are allowing somebody in, but only because of the value they're going to bring to the economy by investing here or employing other people here. We are concerned with rules which are about uniting families. They are all qualifying individuals, categories of case, where the express rule protects the public first. But the point I make, and I hope it's a relatively modest one, is that were these supposed rationales good ones, were it inevitably precarious to rely on a third party, were an underwriting undertaking to be what explains the line being drawn, the examples I've given wouldn't make sense. They don't make sense against those two rationales, whether it's assistance with care, help with accommodation, or for that matter, the employer who's being relied on. The suggested rationale simply won't drive the entry clearance officer's logic. And why not allow a gift to the individual from a family member becomes their own resources? If you can save them rent and save them money spent on care costs, why can't you give them the money that would be the equivalent to the rent or the care costs? And all of this is in the context of family life, where the core value of family life is the ability to be able to rely on others within the family circle. May I give you one reference? At the level of the House of Lords, in a case called Aoku Betts, it's bundle 3, it's tab 19, and in the speech of Lord Brown, citing the case of Huang, it's paragraph 40. And it articulates this very point, all of which is, we suggest, of a piece with the idea you can live with your aunt, or in a house that your aunt owns. You can rely on others. That's what families do. It's page 127 in the report at the very bottom of the page. The core value of family life.
This is a quotation from Huang.
It's from Huang. Human beings are social animals. They depend on others. Their family or extended family is the group on which many people most heavily depend, socially, emotionally, and often financially. There is a very sharp contrast between that approach, which is reflected in the cases on accommodation. The reason why you can live in a room which is in a house owned by a member of your family, or for that matter in a house owned by a member of your family, is because that is part of the common experience of mankind. That's the way people live as families. That's the point made by the tribunal in AB Pakistan, if my lords wish to have a reference, AB Pakistan, Bundle 6, tab 55, paragraph 9. This is the context, and there is a very sharp contrast between that straightforward value, core value and idea, and the approach that is now taken to third-party support for maintenance. You can see that contrast very clearly in the tribunal's determination, which was under appeal in this case. Because if you look at paragraphs 9 and 25 in the tribunal's determination, what was the error of law? They thought it was an error of law to consider the resources of the family.
9 and 35?
9 and 25.
25.
So that's my second topic of the three. Finally, may I briefly turn to my third topic, which is Article 8. It is not necessary, if we're right already on the straightforward interpretation of the rule.
Yeah.
However, it is highly relevant, not least to the suggestion which has been raised, that the Secretary of State could tomorrow amend these rules to exclude third-party support. That we most certainly do not accept. Certainly, one can imagine improvements to the rules in relation to verification. The Secretary of State may, for example, wish to consider provision as regards undertakings from employers. And for that matter, from family members. But the express exclusion of third-party support in this context of family unity, we submit, would not be compatible with Article 8. You've got categories of individuals whose entry to the country is facilitated under these rules. There is a principle which protects the economic well-being of the state, and you can satisfy it because you can show that there won't be recourse to public funds. There is, we submit, no justification for saying, well, you've shown that there won't be recourse to public funds, but you still can't come, and you can't come because you've shown that by reference to another family member. May I make these brief points in relation to Article 8? Firstly, as to the debate on whether the immigration rules guarantee compatibility, we suggest that the courts will interpret the immigration rules compatibly with the standards of justification in the context of family life. But in any event, the immigration rules plainly do guarantee compatibility because Rule 2 of the immigration rules requires the entry clearance officer, under the rules, not to act incompatibly with Article 8. That's Immigration Rule 2.
I'm sorry, how does this work? I mean, just assume that the rule said what you say it couldn't say. I mean, the entry clearance officer says, terribly sorry, you don't qualify under the rules, but as we all know from Huang, he can still qualify under Article 8.
That's right, but there is an intermediate position under Rule 2 of the rules that the entry clearance officer must carry out their duty in compliance with the Human Rights Act.
I'm sorry, I'm completely lost. Assume a rule which makes it perfectly plain you don't qualify under the rules, but the chap's got a cast iron, as it is supposed, Article 8 claim to come in. What's the relevance of Rule 2?
Rule 2 is it imposes a duty on the entry clearance officer to grant entry clearance.
But not under the rules. To grant entry clearance officer because of the Article 8 right.
Well, because of the Article 8 right woven into Rule 2.
But
in any event, I'm not wanting to take a technical point. The point is a point of substance. The entry clearance officer, as a matter of substance, is required to act compatibly.
But it's also got to carry out their duties under Rule 2.
Yes.
And that must mean that they have to apply the rules.
Well,
Obviously, in cases of doubt.
it's not going to matter, but my submission is, suppose you had an immigration rule that had a differential of treatment on its face for women and men. In other words, suppose Abdulaziz happened today. The entry clearance officer would have a duty to say, well, under that rule, you lose. But that rule is incompatible with human rights. It is my obligation to allow your claim. That, in substance, is the position. The point I'm making, again, I hope is a modest one, which is that is reinforced by the rules themselves. But the destination is the same. The entry clearance officer is required to grant entry clearance if one has a situation of that kind.
And that's a Section 6.1 point.
It's a Section 6.1 point, and in any event, Parliament has made clear that as well as being able to appeal on the basis that the entry clearance officer hasn't acted in accordance with the rules, you've got a self-standing human rights appeal. The substance is exactly the same. So if one had a non-compliant component of the rules, it's not a matter for the appellate authority, it's a matter for the decision maker.
I'm sorry, I'm completely lost as to the proposition that you could not have a rule which said, look, in the interests of ease of administration of this law and of protecting the public purse, you can't use third-party funds. And then an applicant fails on that score, of course he may very well have an Article 8 claim to enter, and he may very well succeed on that basis. But he won't necessarily. Not everybody who applies under this scheme has an Article 8 right to come in.
My submission, my lord, is that he will necessarily succeed. And the reason why he will necessarily succeed is because he ticks all the boxes, the criteria, as a category of person for entry, including the one which is the legitimate purpose of the rule, which is economic well-being and protecting the public purse, and he satisfies that. And in those circumstances, that individual, who is necessarily an Article 8 case because they are joining a family member, is able to say there is no justification in circumstances where I tick all those boxes. There is no objective justification. It's not necessary in a democratic society to say no to me, because although I can show that the public purse is protected, it involves my uncle or family member.
But Mr. Ford, I mean, if that's right, well then what's the point of 317 Roman 3? I mean, if all these people, if any relative who comes within the scope of these rules automatically has an Article 8 right to enter subject to this, that and the other, I mean, what...
No, 3173 is part of what I described yesterday as the premise for these cases, are that you need to be here with your relative, and the rules provide for that. If you look at Roman 1, D, E and F, you can't look to someone else the most exceptional, compassionate circumstances. And then 3, equally, is that you have a relationship of dependency.
Financial dependence.
Yes. Now, those are the trigger for when the individual is to be entitled to come to this country, providing no recourse to public funds.
I'm terribly sorry. Just assume that this candidate, in fact, has plenty of money himself. Everything else is as the rule would dictate, but he's not financially wholly or mentally dependent on his son or whoever it is that he wants to come and join here.
Well, the state would in those circumstances be entitled to say that for a parent, grandparent or other dependent, you're not within the qualifying category to come to the United Kingdom. My submission is that where you have a qualifying category of individual, and to take my case, it's the rule in relation to spouses, but one could equally have the child example.
But I'm sorry, are you now saying your proposition isn't extending to 317?
No, I'm saying that if you meet the requirement that there will be no recourse to public funds, if you meet it, there is no justification for excluding you on the grounds that you can meet it but by relying on somebody else. That's my submission.
What do you say is the relationship between Rule 2 and Section 6.1 of the Human Rights Act?
I submit, my Lord, that Rule 2 is the express interwoven obligation within the rules to reflect the statutory duty that the entry clearance officer would have under Section 6 in any event. That's why I've suggested that the debate about human rights not being guaranteed by the rules may be an unhelpful one, because Rule 2 secures, in fact, that they are.
Well,
but
Rule
the point
2
of
can't
substance is...
cut out anything, can't take away any part of the obligation under 6.1.
No, certainly. I entirely accept that. In my submission, the grain, it all goes with the grain. One has the immigration rule criteria, one has the overriding obligation in Section 6 of the Human Rights Act, and for good and proper reason, that is reflected within the express terms of the rules themselves. That's Rule 2.
It may be my fault, but can I just be quite sure that I've grasped what you're saying? You take the individual who can't satisfy 317(3) because he has sufficient resources of his own not to be dependent on the person he seeks to join.
Yes.
317 can't be satisfied.
Yes.
But nevertheless, you say there is a duty under Section 6.1 to consider the Article
No,
8.
I haven't made that submission. I don't suggest that the eligibility requirements which go to the question of the need for an adult-dependent individual to be in this country are impermissible. My submission is a restricted one, and it is that where one has a provision to protect the public purse, I'm addressing Roman 4a and equally Roman 4. My submission is what the state cannot justify in the case of an eligible individual whose need to come here to be with their family member has been satisfied by the other criteria. The state cannot say to them with justification, yes, you can prove that your accommodation and maintenance will not involve recourse to public funds, but we nevertheless are going to refuse, because the absence of recourse to public funds, Roman 4 and Roman 4a, involves you relying on your social relationships, which are the core of your family life. So that's the extent of the submission, and I therefore submit that if we go back to, well, take any of these rules, wherever one has a provision which is securing that there be no recourse to public funds, the state would not be justified in going further and saying it's for us to police the question of their source.
So you accept that the state is justified or can be justified in insisting on little 3?
Yes, I do. And it would be the same. You remember the provisions that related to the child coming to be with their parent. There are provisions that describe the need of the child to be here. It's 297, and it's on page 2946. 297, we looked at Roman 1, D, E and F, and we also looked at Roman 2 and Roman 3.
Yes.
I'm not throwing any of that out. I'm not suggesting there aren't relevant considerations for the rule maker to articulate. But all that I'm saying is that if you meet the qualifications for needing to be in the United Kingdom with your parent because you're a child, you don't have an independent life, this is your only living parent, or the one with sole responsibility, or there are compelling family considerations why you need to be here. All of that's dealt with in the rules, and I'm not saying the rules couldn't be formulated in a different way in relation to all of that. My submission is simply this, that when the state is asking the question whether you are able to be accommodated and maintained without recourse to public funds, if you can answer that question, yes, and I can prove it, the state has absolutely no business, it has no legitimate interest in saying, well, money from your husband's okay, but money from your husband's brother is out.
Well, supposing that, I'm just trying to understand the answer, supposing that all the other ticks all the person coming, ticks all the boxes except 3, what's the justification for the Secretary of State interesting himself in whether or not the person is at the present moment wholly or mainly dependent on that person? And why can't you just say, well, that's none of his business, it's not going to be any drain on the state, he's coming here, all will be well. What does it matter?
I would accept that issues could arise in relation to that, but it's no different from Roman 3 in 297. And maybe issues will arise in particular cases under Roman 3 in 297. The rule says you've got to need to come here. If you're already independent in your life somewhere else, you left school at 16, you've got a job, you just don't need to be here with your parent, then different considerations arise. I'm not arguing that case, and I'm making no concession relating to that case. I'm simply articulating the submission that I am advancing, which I know that my lords have.
And the submission is made on the assumption that you're wrong on the point of construction.
Yes.
And this is not a construction argument then at all?
No. This is an argument that's driven by human rights considerations, and therefore the same conclusion is compelled in any event. Ask yourselves the justification.
I thought it was a construction argument.
Yes, that's what I'm maybe difficult to understand it, because I can see it if you're saying, well, the officer has to read the rules in the light of what section.
Can I explain it in 3 steps?
Yes.
Step 1, I don't need any of this, because on this...
We know that.
Just so you understand, because I'm obviously not making it as clear as I should, as to how this relates to construction. The natural construction supports me in any event is my first submission. My second submission is that if the court is faced with a choice of interpretations, it should choose our interpretation. So that's to say if there is an ambiguity in the rules.
That's a Section 3 point then, is it?
Well, it's the analogue of a Section 3 point, but I don't need Section 3 in order to rely on it. If I'm right, and if there's an ambiguity, then the court should do what courts have always done and did long before the Human Rights Act, which is to interpret the provision in accordance with this state's international obligations. Why would one want to do other with a rule which is directly dealing with family life and is open to that interpretation?
No, but what I have to realize me is that your proposition rests on the basis that actually everybody who ticks all the boxes is by definition an Article 8 case, and that there is simply, you can't therefore, in the interests of easier administration, to eliminate the greater precariousness and all the other problems and all the rest of it, you simply cannot superimpose any additional requirement.
First of all, they are Article 8 cases, just as Abdulaziz and the men and the women being joined by their spouses. They are all engaged Article 8 of necessity. That's the first point. And secondly, on the narrow submission that I make, one is left, and left only, with this stark question. Namely, whether in the case of someone who can prove that there'll be no recourse to public funds, that being the criteria in the rule, there can be a justification in the state overreaching that and saying that we have an interest in saying, but it can't come from anyone other than a named family member. And if that can't be justified, and we say couldn't be justified, then we suggest better to face up to it. My third step is that if the rule were plainly and unambiguously against me,
Yeah.
or if it were formulated tomorrow in the way that the Secretary of State has formulated rules for artists and retired persons of independent means, who of course don't engage any family life imperative, then it would be incompatible. In other words, entry clearance could not lawfully be refused by reference to the exclusion of third-party support if the absence of recourse to public funds has been demonstrated. It couldn't be. It wouldn't be justified. That's the position of substance. It matters not whether the court would say that, so that we all know that that component of the rules cannot be applied by the entry clearance officer to the detriment of the individual, whether the court would go on to quash the rule, whether the court would say, well, the rule is intact, but there's a duty, whether the court would say that duty is under Section 6, or whether the court would say that duty is under Rule 2. The position of substance is exactly the same.
The logical consequence of that must surely be that Roman numeral 3 in 317 cannot be justified where a parent is independently wealthy.
The reason I haven't accepted that is because it is open to argument that 3 is an aspect of the need of the wealthy parent or grandparent to come and be with their family. It has the same sort of function as the child provisions that say if you are already living with one parent overseas, you don't need to come to this country to be with the other parent. That is, I have suggested, why it is different and can play a different role and have a different function.
Well, if you refine the example, let us suppose it's an independently wealthy father. His only children are living in this country and he wishes to be reunited. Can there be any justification for the imposition of a financial dependency?
Well, it may be that there can't be, but that's not the argument that I have articulated. I wouldn't accept that it necessarily follows from the argument that I have made. I see the point, and I see the considerations that would arise in that context. And, my lords, unless there are any further questions for me, those are the 3 topics that I wish to deal with in completing our submissions in the context of this first appeal, and as you know, I adopt all of them in respect of the second appeal,
Yes,
which raises a discrete issue.
Yes. Mr. Nathan, I don't know where you are. Would you wish to follow? Thank you very much. Now, Lord Paddock, I think it's your turn, isn't it?
My Lords, the answer to the question posed by the Deputy President at the beginning of the hearing yesterday morning is that there is no need for anonymity in the cases of KA and MI, who I represent. On the issues of construction, and indeed Article 8, which the Court has heard, I adopt the submissions of Mr. Gill and Mr. Fordham. My task is to address 2 particular issues of construction which arise in the cases of KA and MI. They are, first of all, whether third-party financial support is permitted under Rule 317, Roman 4a. And the other point is whether, for the purposes of Rule 317 and for the purposes for the purposes indeed of Rule 297 as well, can there be joint sponsors? And if so, is it necessary for them to be named as such on the application form?
Yes.
Now, my lords, the statement of facts and issues does
Can I
not
just-
raise...
Sorry, can I just catch you? You're laying out your thing. Are you dealing with little 3?
I will deal with that as part of my argument.
You will have to deal with that
Yes,
as part of it.
I
Yes.
will.
Sorry.
The
Yes.
accommodation point.
It doesn't arise, does it, in your case, or does it?
The accommodation point, no.
3173.
No.
Well, I thought 3173.
3173, the dependency
Yes.
point, no, is not an issue, but I will address that because I know
It would
that
be
your
helpful
lordships
if you
are
did.
concerned with it. I will have a submission to make on
Yes,
it.
thank you very much.
Now, in relation to joint sponsors, can I just be clear about this? The statement of facts and issues does not raise the question of whether there can be joint sponsors in principle. And that matter was decided in our favour by the Court of Appeal. But the ECO does wish to raise that question, whether there can be joint sponsors at all. And I'm very happy to deal with it. I have no objection to the point being raised, and it won't take very long for me to make my submission on it.
Yeah.
Now, my lords, the facts of my case, KA and MI, illustrate in my submission the reality of many applications to enter this country. The reality that family members, more than one of them, will be contributing inevitably to the maintenance of the entrant. And my case is that if the rules are to exclude such reliance, one would expect them to say so expressly, given that the context is family unity. Does the court have our core volume available? It's the one that has the names of my solicitors in the bottom left-hand corner, Jackson and Cantor.
Yes, I got the appendix. I don't have the core volume with me, but which bit are you going to refer
Well,
to?
I'm going to take your lordship to the appendix.
That's fine, yes. Now, just to be sure I've got the facts, KA, I'm using the initials just for convenience. KA is seeking to join her daughter
Yes.
here and is relying on the financial support of her granddaughter.
Of her granddaughter, yes. The daughter's daughter. The daughter is Anab,
Yes,
and the granddaughter is Ayan.
that's right.
Flying on both, I thought.
Yes. And I'm going to show you, lordships, how this arises. Very briefly, I'm going to show the court, if I may, the application form that makes very clear what was being said. If the court has the appendix, and please would go to page 59. This is the application form of KA, the grandmother.
Yes.
And on page 62, at the top of the page, she's filled in paragraph 4.1, your sponsor's name. And the sponsor's name, Anab, is her daughter. Her daughter who's settled in this country.
So that is the relative that she's seeking to join in
Yes.
terms of the rule.
Yes.
Yeah.
She's filled in the daughter as the person that she wants to join in this country. The daughter, Anab, is the aunt of the other appellant, MI,
Yes.
who, of course, whose father is dead and whose mother's whereabouts are unknown. But if one travels down page 62, halfway down the page to question 4.15, the question appears, is your sponsor responsible for the financial support of anyone else? Answer yes, see below. If you've answered yes, please give details. Sponsor receives income support for self and family. Granddaughter, Ayan, will provide third-party support. So the form makes clear that there is going to be third-party support from the daughter's daughter, also settled in this country, Ayan. And then on page 63, halfway down the page, section 6, your circumstances when you get to the United Kingdom, the address is given at 6.1. At 6.3, what is the basis upon which the sponsor occupies the property? Well, she's the tenant. And then we're told how many bedrooms there are. 6.6, please give details of anyone else who lives there. And we see who lives in this house. The daughter lives there, she's the sponsor, but also Ayan, the grandchild, lives there. So the family live in the same property. Over the page, on page 64, at the top of the page, is your sponsor in employment? No. And she's written in, but third-party sponsor Ayan is in employment, and her details are given. And at 6.17, will you or your sponsor receive income from any other sources? Yes, Ayan, that's the granddaughter, will provide all living expenses. And on page 65, at the end, section 7, any other information, the sponsor is the applicant's daughter. The applicant's granddaughter will ensure sufficient income so there is no recourse to public funds. Obviously, they knew Mr. Gill and Mr. Fordham's submission as to the importance of that. But that's what has been said. And MI's form appears at page 69. That adds very little because all the way through, as one can see from the top of page 72, paragraph 4.1, see the application form of the grandmother.
Yes.
KA. So it adds nothing at all. So that's the context. Now, may I make a very brief submission, my lords, on the general principles for interpretation of these rules? Because
before you get there, I'm sorry to keep interrupting you. Just to get my bearings, if you look at page 41 in the appendix, paragraph 32, we're looking here, I think, at the AIT's decision.
Yes.
And paragraph 32 is referring us to paragraph 317, little 3 of the rules. And as I understand that paragraph, he's saying that requirement is not satisfied because Ayan is going to be going to be providing the benefits, and therefore can't be said to be wholly or mainly dependent on the relative, that is, the daughter.
Because the money is going to come
from the granddaughter.
From Ayan. Yes, well, I will deal with that.
Yes, I mean, I'm just highlighting why I think this point matters for you too.
Yes, I understand.
Well, that wasn't identified as a problem in the Court of Appeal.
No, it wasn't. It's not an issue in the Statement of Facts and Issues either, but it is there.
No, well, I recognise that, my lord. I will address that question.
Right. Sorry, but I interrupted you
No,
because
not
you were
at all.
taking the principles.
General principles for the application of the immigration rules. There is arising from the printed case for the respondent an issue that arises as to how the court or tribunal should address the immigration rules, and that's because in the printed case of the respondent, does the court have the printed case of the respondent in all these cases, the court will see at paragraph 6.2 on page 3 how the respondent puts it.
Can you give me the reference again?
Yes, it's respondent's printed case, page 3, paragraph 6.
Yeah. Yes.
And your lordships will see that the respondent submits that the functions of the rules are to set out the Secretary of State's policy on the entry of certain classes of foreign nationals. The question of interpretation is therefore what the Secretary of State intended his policy to be in relation to such persons. Now, we, with great respect, take issue with that approach. It is true, of course, that the rules are intended to state the policy of the Secretary of State. No one would dispute that. But this does not mean that it is the task of the court, when interpreting the rules, to identify as a matter of policy what the Secretary of State intended.
It would be right if it said the question of interpretation is what the Secretary of State must be taken to have intended.
Yes, by reference to the language of the rules. My concern is that that paragraph suggests that the task of the court or tribunal is to identify what the policy is. The task of the court, as with any other legal document, is to interpret the words that have been used, of course, in their context. And the words that have been used, understood in their context, may mean something very different from what the Secretary of State intended as a matter of policy. And this must be so because otherwise there would be no point whatsoever in the content of the rules, the relevant instrument, being put before Parliament under Section 3 of the Immigration Act for Parliament to have the opportunity to consider the rules and disapprove of them if Parliament sees fit. So the rules, the content of what has been presented, is of fundamental importance. The other question I just wanted to touch upon as to proper interpretation is that if one moves on in the respondent's printed case to paragraph 37, the court will see, and I know from my friend Ms. Cars-Frisk's authorities that she intends to develop this point, part of the case for the Secretary of State will be to draw to the attention of this court the instructions that have been given to immigration officers by the Home Secretary. And our submission is that instructions given to officers by the Home Secretary cannot override the content of the rules. Now, there is a case in which the role, the function of instructions from the Secretary of State to immigration officers has been addressed. It's ZH Bangladesh. And I don't know whether that's been put on your Lordship's desk.
Court of Appeal decision, yes, we have.
I'm grateful. It's Lord Justice Sedley, Lord Justice Keane, and Lady Justice Smith.
It wasn't, when Mr. Gill drew our attention to, was it AI Pakistan?
Yes, he did.
Was that does that not go to the point?
That also, I think, went to the point as well, yes. Yes, but here, Lord Justice Sedley, early in 2009, is expressly addressing the question of the function of the instructions.
Does it look back to AI Pakistan?
It does not mention, I don't think, I'll be corrected if I'm wrong, does not mention AI Pakistan, nor, I regret, does it mention the statutory provision which addresses the role of instructions, and I'm coming to that. But can I show your Lordship, just very briefly, what is said by Lord Justice Sedley here for the court in relation to instructions. At paragraph 26, pages are not numbered, I regret, paragraph 26, he comes to what he says is an issue of general importance, which has come into focus in the course of the argument before us. What is the legal or evidential status on appeal of the directions issued by the Home Office's Immigration Directorate to its officials about the implementation of rules or rules in play before the AIT? And there's some detail, and then he comes to the heart of it at paragraph 32. And he says at 32 that two things are reasonably clear. The first is that the instructions cannot be treated as if they possess the force of law, The other is that at least in a case such as the present one, the instructions must have a legitimate bearing in the sense it would be wrong for the immigration judge to adjudicate in ignorance of it. Between those poles, one can locate two further propositions. First, albeit its author is in law the author of the immigration rules, the instruction manual is not an aid to the construction of the rules. Secondly, in assuming always that it sits as it must within the four corners of the rule, the significance cannot depend on whether it steers caseworkers towards a restrictive or a generous application of the rule. If counsel can use the present instruction because it helps him, the presenting officer in another case can use another instruction for the opposite reason. In both such cases, the instruction becomes a surrogate for the rule, which is not permissible. Follows the proper course is not to introduce the material instruction every time the meaning or application of the rule is in issue, but the presenting officer should be ready to explain to the tribunal any divergence between the case now being presented and any material instruction to which the tribunal's attention is drawn. This approach, without placing an undue burden on the Home Office, reflects the legal obligation of government not to act inconsistently with its own policy unless there's some good reason for doing so. More than this would be to give internal guidance the force of law. Less would be to tolerate double standards in public administration. And of course there is a problem if the rules are to be subordinate in any way to the instructions. This again would undermine the statutory obligation in section 3 to place the rules before Parliament for its consideration and approval or disapproval, a constitutional point. Now, none of the printed cases, so far as I can see, and certainly not this case of ZH, refer to the relevant statutory provision, which I much regret is not in the materials before the court. But there is a provision. Can I give the court the reference and we will photocopy it for the court? But in the Immigration Act 1971, in Schedule 2, at paragraph 1, subparagraph 3, Parliament has said that in the exercise of their functions under this Act, immigration officers shall act in accordance with such instructions, brackets, not inconsistent with the immigration rules, close brackets, as may be given them by the Secretary of State. So that's the statutory origin of instructions, statutory role of immigration instruction. Schedule 2 of the 1971 Act, paragraph 1, subparagraph 3. Immigration officers shall act in accordance with instructions so long as they're not inconsistent with the immigration rules.
I think that would mean that Lord Justice Sedley maybe went a little bit too far when he
Indeed.
said... Yeah.
Indeed. So they do have a statutory function, indeed so. In other words, if the rules are silent on a matter, then of course the immigration officer is entitled, indeed bound, to comply with instructions. But the instructions have a subordinate role to immigration rules. They cannot displace the content of the rules that have been approved by Parliament. The first issue then, if I may come to the issues, the first issue under Rule 317, sub-rule 4A, is whether it allows the applicant to rely upon the financial support of a third party. That is someone other than the sponsor. And our case, echoing Mr. Fordham and Mr. Gill, is that the object of the rules on the language that is used is to prevent a further burden being placed on public funds. That is the focus of Rule 317 Roman 4A. Just as it is with rules 281 and rule 281 and 297
and rule 4 in 317.
I'm sorry.
Rule 4 in 317.
Indeed so, and rule 4. they all march together in this respect. They can be compared, should be compared and contrasted with Rule 232 Roman 4 for artists, writers and composers, and Rule 263 Roman 3 for persons of independent means. My Lord Brown asked, well, why is it in those other contexts, what is the policy reason why the Secretary of State has adopted a different approach? I assume in the context of persons of independent means, it is simply inconsistent with the notion of being a person of independent means for the applicant to say, I am relying upon funds provided to me by a third party. The whole point of the category that you are a person of independent means is that you have the necessary wealth. And the policy is quite simply not to allow people to enter this country who fall under no other category. They're not a family case, they're not a refugee, simply because they have wealthy friends. No doubt a case could be made for such a policy, but it's not the policy of the Secretary of State. And it's perfectly logical that it shouldn't be the policy of the Secretary of State. In relation to artists, writers and composers and Rule 232, again my Lord Brown says, well, what is the policy? Well, the policy, quite simply, is that in this category, only successful writers, artists, composers are welcome. Again, perfectly logical to say we're not prepared to welcome the young Van Gogh or the young James Joyce, or indeed the rather older Van Gogh or James Joyce, but we're not prepared to welcome them to this country. Views may be taken on the wisdom of that policy, but that is the policy, and it's a perfectly logical policy to adopt. It's perfectly understandable why the rules draw the contrast that we see drawn. And our case, very simply, is that if the Secretary of State wants to amend Rule 3174A, then he's perfectly at liberty to do so, subject to Mr. Fordham's Article 8 points and the strength or otherwise they may be held to have, and subject, of course, to getting the approval of Parliament, or at least not incurring the disapproval of Parliament. Now, in relation to...
Sorry, can I just... what was that further rule that it spilt over to that Mr. Fordham was telling us about, which I don't think is an Article 8 case? The one where... remember he showed us how nowadays it's this business is said to exclude third party. Am I aberrating? Earlier on this morning...
95, yes, thank you, I'm told from behind.
95.
India, 95 was the
It's
one.
working holiday makers, isn't it?
The working holiday makers. Yeah.
Sorry, can I just go back to 95?
Of course.
I hope Mr. Fordham, forgive me for putting it this way, but I don't think even Mr. Fordham would suggest that Secretary of State couldn't amend that one to make it clearer.
Let's put it this way, the working holiday makers are not promising fertile ground for Article 8 arguments.
Quite.
Indeed so.
I hope you'll forgive me putting it the way I did.
No, indeed so, my Lord. Now, in relation to the proper construction then of 3174A, our point is that there's no suggestion in the language of 3174A that third-party financial support is prohibited, that it's excluded. My Lord Brown put yesterday, I think, to Mr. Gill in the course of argument, that the language of 317 Roman 3 might support the argument for the ECO in relation to 317 4A. And may I attempt to address that point? 317 Roman 3 is concerned, of course, with the question of the dependency of the applicant abroad at the time of the application. That's what we are concerned with.
That's
Contrast.
the word is, then. You're putting the point on the word is, present time,
Yes.
present tense rather.
Yes, I mean, it's asking the question, as at the time of the application, which is the relevant time for this purpose, whether the person who is abroad is wholly or mainly dependent on the relative present and settled in the United Kingdom. And that's the question. And the contrast with 317 4A is that the latter provision is concerned with the distinct issue of the financial position going forward once the applicant arrives, if he does, in this country. And of course, the likelihood, it's not inevitable, but the likelihood is that the latter cost, that is the cost going forward in this country, is very likely to exceed the amount that's needed to maintain the person in their home country. It's almost inevitable, given the experience of the immigration rules, that people are going to be coming to this country from the Indian subcontinent or elsewhere, where the cost of making provision for them is less than it is in this country.
Well, I agree that will usually be the case, but I mean, actually, this applies equally to somebody coming from...
Oh, it does. It does. But the rules are drafted with that knowledge in mind. And whereas the rules expressly exclude the case where the applicant has in his own country another person, another close relative, on whom he can turn for financial support. That's 317 Roman 5. There's an express exclusion of other persons in his own country. One takes note of whether there are other close relatives in his own country to whom he can turn. There is, by contrast, no reference, no suggestion in 317 4A that one should exclude, as a matter of principle, financial support that is to be provided in this country by a relative who is not the sponsor. And I say that is very striking indeed, that contrast is drawn. The person in his own country, since he is seeking to come to this country on the basis of financial dependency, is excluded in circumstances where there are other close relatives in his own country who could provide the financial assistance.
I mean, perhaps you're entitled to put a little bit of weight on the word mainly, because mainly indicates that there could be a shortfall that therefore could be filled by third parties under Roman 4A.
Well, indeed. That's the next, but this is under 317 3. We do invite the court to note that even in relation to the position in the foreign country, sub-rule 3 does not require the applicant to show that he is wholly dependent on the relative in this country.
But of course, in that situation, there isn't any risk of recourse to public funds, is there? If you're talking about the position in his own country at the date of the application, so it's a different problem. here, really.
Well, I respectfully agree, but it would be striking, I respectfully suggest, if the rule recognises that it is permissible in relation to the position in the foreign country to have a case where the applicant is partly dependent on funds provided by a third party in this country, and yet when the applicant arrives in this country, for the rules then to prohibit any note being taken of financial support by a third party in this country. That again would be a very striking contrast between the different aspects of the rule. So our respectful submission is that 317 Roman 3 does not assist the case for the ECO. On the contrary, it supports our arguments that there's nothing in 317 4A that prohibits reliance being placed on third-party support, and the contrast with the provision of Roman 3 and Roman 5 illustrates that if the Secretary of State wished to restrict the scope of 317 4A in the way that is being suggested by the ECO, it would be perfectly easy to draft a provision that expressly stated that the maintenance may only be provided by the relative present and settled here on whom the applicant was dependent when abroad, or a provision to
I mean, I absolutely follow all that, and I see the force of that in respect of 4A, and 3 doesn't, you could say, doesn't therefore infect 4A, but 3 is there. I mean, it's apparently not a problem for you in your case, but I mean, on the face of it, there it is as an absolutely self-standing obstacle to those who can't satisfy it.
If there are cases where there is no financial dependency at all on the person in this country, then I recognise the difficulty that arises under Roman 3. But again, one would interpret, I would suggest, the phrase mainly so as to recognise that some financial dependency would suffice. One would then proceed on the basis of of which relatives fall into this category. But I, for my part, I think would have to accept that, subject to Article 8 considerations, which I'm not going to address, but subject to that, this is a rule which is designed on its language to focus on financial cases of financial dependency.
It's quite difficult. I mean, if one looks at the end of E and end of F,
yes,
the person, these people, like a son or something, has got to be mainly dependent financially on relatives.
Indeed.
Settled.
Indeed.
I mean, so that's the, and then further down, he's got to be mainly dependent on the relative. I mean, it's not very easy to.
Well, it's not, and I respectfully rely on 317 Roman 1 E and F, which is a demonstration that it is not the intention of the Secretary of State always to require one relative and one relative alone. And I say that's perfectly understandable that the Secretary of State is not going to preclude cases where the financial dependency, wholly or mainly, is based upon the contributions, the financial contributions that come from more than one person in this country, a family getting together or a group of persons supporting the aged relative or the younger relative in the foreign country. And it would, I say, be striking indeed if the purpose of these rules is to preclude the case where the aged relative, the father or the grandfather abroad, is relying upon the support, the financial support of the three daughters in this country, the King Lear example. I mean, it's quite nonsensical to say that you satisfy the rules if you have one daughter, but you don't satisfy the rules if there are three daughters who together provide the assistance either while you're in India or wherever, or when you arrive in this country. That is, in my submission, quite nonsensical.
When I'm just as a pure matter of interest, when they talk about compassionate circumstances, is that pitiable sort of? Is it terrible poverty, or what are they talking about? Compassionate, in living in compassionate circumstances.
Yes, I mean, it's the most exceptional compassionate circumstances.
Yes.
It's recognising that where the individual is over 18, they don't fall within the limited categories that are set out before. There may be cases where they're living in appalling poverty, or there may be cases where they suffer from mental illness or some other impairment, maybe a physical problem that makes it inhumane, very
or being
unjust.
Exploited or something.
Yes, something of that sort. It's plainly designed to be a general phrase that should not be limited by particular examples. And there is, as in all of these areas, a host of case law, most of it looking at particular facts, addressing the context. Now, as the court knows, in the Court of Appeal, Lord Justice Carnwath essentially accepted this submission at paragraph 104 of his judgment, and he noted that there were two arguments that were adopted by the majority, Lord Justice Laws and Lord Justice Pill, against this reasoning on Rule 317(4). And the first of them was based on the role of the sponsor, and the second argument was the previous Court of Appeal judgment, which this court has seen in M.W. Liberia. Now, as to the role of the sponsor and the suggestion that the financial support under 317 Roman 4a can only come from the sponsor, the short answer is that there's no mention in 317 4a of the sponsor. There's no restriction on where this maintenance may lawfully come from. It is true that it is open to the respondent, open to the ECO, to require a sponsor to give an undertaking, and the court has seen the basis for that. It's in Rule 35. We say that the mere possibility, because it's only a possibility, that a sponsor may be asked for an undertaking cannot affect the proper interpretation of the language of Rule 317 4A, and that's the point made by Lord Justice Carnworth in paragraph 106, in the second part of paragraph 106, at the top of appendix page 30. But we do also draw to this court's attention that even if a sponsor is asked for an undertaking and the sponsor refuses to give an undertaking, that is not, under the rules, a mandatory basis for refusing entry clearance. And one sees this at paragraph Rule 320. If I could ask the court, please, to go to that. It's volume 1, tab 8. Rule 320 can be found on page 2965. Rule 320 begins by setting out grounds on which entry clearance is to be refused. In other words, mandatory grounds for refusing entry clearance, and there's a number of them, 1 through to 7b. And then we have, starting at the sub-rule 8, grounds on which entry clearance or leave to enter should normally be refused, but in respect of which, therefore, the ECO has a discretion. It's a matter for the ECO. And we see over the page at Rule 14, at the top of page 2967, sub-rule 14, one of the discretionary grounds is refusal by a sponsor of a person seeking leave to enter to give, if requested to do so, an undertaking in writing to be responsible for the person's maintenance and accommodation for the period of any leave granted. So it is not a mandatory ground of refusal by the ECO that an undertaking has been sought and declined. The ECO may or may not refuse entry clearance in those circumstances, and we say that supports the argument that it cannot be the case that Rule 317 4A should be read as compelling an approach that financial support may only be provided by a sponsor.
(317) 1E and F, they were always there with a reference to the relatives. I think it looks as if they were. D.
I wouldn't say always, but they have some considerable history. We can trace back.
I'm just looking at the note on page 2960. We see that D came in, I don't know when HC 582 was, and then we see that the Roman 4 and 4A came in, I don't know when, but on the face of it, I mean, they 4 and
317 1E and F are of some antiquity.
Yes, it's rather sort of odd that the definition of sponsors way back in the rules doesn't sort of cater to that. I mean, who is the sponsor in respect of one of these 3171E?
E and F, where there's more than one relative.
Yeah.
Well, in my submission, that goes to confirm the submission I'm coming to in a moment, that it cannot be right as a matter of principle, as the ECO contends, contrary to the Court of Appeal's judgment, that one may only have a single sponsor under these rules. That cannot, in my submission, be correct.
Well, it's just, I'm thinking aloud a bit on how one construes the word relatives in the plural. The striking fact, the feature of D and D and F is that there are several people mentioned there.
Yes.
And it could be that drives or drove the writer to put the relatives in the plural. Whereas in A, B, and C, well, no, it's not perhaps as easy as that, is it? It's
it would be, with respect, a
yes.
very odd
It is
form of
odd,
drafting.
right?
One would say on a relative.
yes.
If one intended to
The
suggest that it would be one of the above.
Yes.
Well, the Interpretation Act enables
Well,
the
precisely.
court to deal with this in a common sense
Section
way.
6, isn't it, the Interpretation Act, the singular includes the plural, unless the context otherwise requires, which in my submission, plainly here it does not.
But I mean, is there anything in the rules except for the definition of sponsor, and then you come to the provisions of Rule 317 that actually tells you how you set about applying?
How you apply for entry
and,
clearance?
you know, who you apply to join, so to speak.
I see. Not as far as I'm aware, no. There's nothing else. Your lordships have seen all the relevant rules, and indeed, as I shall emphasise in a moment, there's not even a mandatory requirement to use a particular application form.
No, I appreciate that.
Yeah. The Lord Justice Laws is looking to what he describes as a concrete effect of the family unit in question. So it's he's suggesting that the whole idea of the sponsor is integral to the idea of the family unit, and it will depend on the facts. But I think that's what he's really saying in 56 and 57. He uses Rule 35, as you've explained.
Yeah. Well, and our answer to that, as was the answer of Lord Justice Carnworth, is that the sponsor has a role insofar as the rules so provide. But one cannot, in our submission, read in to a general provision such as 3174A a requirement that the financial assistance may come only from a particular person. It does violence with respect to the language of the rule, and it ignores the contrast with other rules which do identify, where appropriate, where money comes from or where the individual can look to for the receipt of money. And there comes a point, we make this point in our printed case, there comes a point where one is running up against the principle stated by Lord Hoffman for the Judicial Committee in Matadine. This is paragraph 11 of our printed case. The well-known statement that whether you're seeking to interpret a contract or a constitution, it is simply not open with respect to the court to move away from the language as Acting Justice Kentridge said, and Lord Hoffman quotes him in the State and Zuma, if the language used by the lawgiver is ignored in favour of a general resort to values, the result is not interpretation, it is divination. And one does arrive at that point if one is seeking, as Lord Justice Laws suggests here, to interpret these specific provisions by reference to what he says, his lordship says, is the function of the sponsor. The sponsor does not have, in our submission, an overarching role here. His role, his responsibilities are carefully identified, where relevant, by the immigration rules, which, as I've said, are put before Parliament. And I say it's quite wrong to displace the language and give a role to the sponsor that the rules simply do not give. The other basis for the majority of the Court of Appeal's reasoning was the judgment of Lord Justice Tuckey in M.W., and the Court has already seen that, and I have nothing that I wish to add to what my friends Mr. Gill and Mr. Fordham have said. I adopt their submissions. The other point that is made by the ECO on Rule 3174A is that the ECO says, and Ms Cars-Frisk will emphasise, that third-party support is more precarious. It's more difficult to verify. To which our answer is, well, it will depend. It will inevitably depend on the facts of the individual case. And it is incumbent on the applicant to satisfy the entry clearance officer on the facts of the particular case that the entrant can and will be maintained adequately with any dependents without recourse to public funds. There may be cases where third-party support is rock solid, where the ECO is satisfied that it is verified and it will continue to be provided. And indeed, as my friend Mr. Fordham pointed out this morning, if there is a commitment to a close relative, the ECO may easily be satisfied that the third-party support is not precarious at all. And in any event, if the Secretary of State does believe that there are good policy reasons to confine Rule 317 Roman 4a, then, subject to Article 8, he is at liberty to redraft it, to say so, and let him put it before Parliament for their approval or lack of disapproval. So we invite this court to give Rule 3174A its natural and ordinary meaning on its language. It does not require funds for maintenance after arrival to come only from the sponsor. The meaning of Rule 3174A, to use the metaphor that Lord Justice Laws expressed at paragraph 38 of his judgment, is worn on its sleeve. The sleeve is the words, and those words are what govern the matter. May I turn to joint sponsors, not forgetting, of course, the point that Lord Hope, my Lord the Deputy President, has asked me to address, which I will address. May I turn to joint sponsors before I do so? Because another way of arriving at the same result is to recognise that there can be joint sponsors in this type of family case. Now, the Court of Appeal agreed with the appellants.
Sorry, can I just, I'm terribly sorry to, you only need to win one of these arguments?
If I can satisfy your lordships that in the case of KA, third-party support is sufficient.
Well, then, end of story.
End of story. If this court is prepared to accept, as the Court of Appeal did, that these two cases must stand and fall together.
Yes. Well, that doesn't seem to be an issue.
It's not, as I understand it.
Fine.
But
So,
it's plainly important in my submission to address the question of joint sponsors, because that is an alternative way.
yeah, quite. I mean, even if you're wrong, and everybody's wrong on third-party support, if you've got joint sponsors here and you don't have both to a category clearly so on the form, I mean, that's where all the support's coming from here. In this case, there's no third-party support except from the two joint sponsors.
In my case,
That's
yes.
right.
Precisely so.
No, I'm sorry. I'm sorry.
That's true. Very helpful.
I was rather
But there's an issue of principle here, because the ECO says, through my friend, that you can't have joint sponsors at all. You must have one person who is the sponsor and one person only. Can I remind the court of what the Court of Appeal said? Lord Justice Laws addressed this matter at paragraph 92. and it's the second half of paragraph 92 of the judgment, appendix page 27, where his lordship says plainly, where the sponsor is a spouse, fiancé, or civil partner, there can only be one. But his lordship did not see why a person may not seek entry to join more than one person, such as brothers or sisters, or it may be other relations as their dependent relative. And in that case, the brothers or sisters, plural, may jointly be named as sponsors. So that was the view of Lord Justice Laws. Lord Justice Carnworth agreed with that. It's the first sentence of paragraph 112. He simply says he agrees with Lord Justice Laws on joint sponsorship being permissible in law. Lord Justice Hill, for his part, was more cautious at the final paragraph, 127, of his judgment. He said that he could see the merits of joint sponsorship as a means of giving a proposed entrant the opportunity to rely on the joint incomes of two members of the family, but his lordship would reserve the question whether joint sponsorship is permissible under the rules for a case where the issue arises.
I mean, it doesn't look as if they could have been referred to 3171E and F, does it?
It appears not, Lord, no.
I mean, it's a little difficult to see how 3171E and F marry up entirely with 3173, which puts it on the relative present and settled. I mean, isn't there a sort of curious discordance between the two? I mean, E and F seem to think, well, it's absolutely fine if you're mainly dependent on 2 or 3 or whatever it may be, and then you come to Roman 3 and it is in the singular.
Well, indeed. Well, I'm coming to the proper construction of 3173, and my submission will be that it cannot, not least in the light of 3171E and F, and in the light of the fact that it talks about either wholly or mainly dependent, be intended to require that it's only one person who is providing the financial assistance while the individual is in the foreign country. And indeed, it makes no sense because of the example I gave of the man who has his 3 daughters in this country. I mean, what sensible policy would seriously suggest that it is a requirement that the money only come from one of the children and may not be shared out between 2 or 3 of them, provided that the ECO is satisfied, of course, that there is a genuine financial dependency of the appropriate sort. So there it is. The Court of Appeal accepted that one can have more than one sponsor. There is indeed an Immigration Appeal Tribunal case to that effect. GG, if your lordships would go to volume 6 of the authorities. This was a case that had regard to 3171F. Tab 57 of Bundle 6.
Yes.
And as the court will see from paragraph 2, the tribunal is dealing with Rule 317. At paragraph 5, there's a reference to 3171F read with 3. This is the point that Lord Brown was just making. Mr. Deller, who I think is the Home Office presenting officer. And yes, Mr. Deller is the very experienced Home Office presenting officer. Indeed, one sees that from paragraph 1. As Mr. Deller, this is paragraph 5, has pointed out to us, there is a difficulty in reading paragraph 3171F with 3173. The difficulty arises from the use of the plural in the former and the single in the latter. So far, therefore, there's no assistance to be gained from the rules in deciding whether it's possible for the purposes of 317 in general and 3171F in particular for there to be more than one sponsor. So they address, the tribunal are cognizant of that problem. At paragraph 10, turning now to the issue, the first question must be whether in principle there can be two sponsors. As Mr. Della frankly admitted, this is a matter on which even the rule itself is unable to take a consistent line. That's the reference back to paragraph 5. We take the view the terms of the application form, indicating as they do at the points which we've set out the possibility of more than one person being a sponsor, concede that a sponsor can in principle consist of more than one person. That indeed is what we should have expected. It cannot be unusual for a dependent relative to seek to join a married couple. It's not unusual for sponsorship to be provided by a charity or some other body which may not have legal personality and therefore may formally consist of more than one person. The question then is how joint sponsorship feeds into the requirements of the rules. It seems to us that provided that all the individuals who together comprise a sponsor have severally undertaken the responsibilities of a sponsor, it's unlikely to matter very much where the support is found for accommodation and maintenance. Whether it be possible for one individual to undertake accommodation and a different individual to undertake to provide maintenance is a question which doesn't arise in this appeal, and we rely.
Is the reference to a charity sound? Can a charity really be a sponsor within the meaning of the expression?
Not in the context of, in the context of family unity. Plainly, there has to be family that one is joining. Your Lordship's asking for the purposes of paragraph 35.
Yes.
Whether a charity may be a sponsor. Certainly, as I understand that judgment, it is the experience of the tribunal that does occur. The tribunal would not be so stating unless sponsorship is provided by charities. And he is the Deputy President. Yes, Mr. Oppleton, of course, has a wealth of experience of these cases. There is nothing, I think, I'll be corrected if I'm wrong, nothing in Rule 35 itself which precludes sponsorship being given by a charity. And of course, in this context, one may well expect that there would be many cases where people are coming from particular countries which have persons from those countries and those communities already present in this country. And it no doubt is very often the case that the financial demands of the Home Office are satisfied by the community through its charitable entity, assuring the Home Secretary, assuring the ECO, and the ECO being satisfied, that financial provision will be made.
Yes. Well, the word is defined on page 2791, and it looks as though the framer of the rules had in mind individuals.
I don't think actually in paragraph 10 they can have been meaning, I think they use sponsorship there and simply in financial terms. Yes. I don't think they're meaning that the charity is actually the sponsor. Because don't forget, this is a decision in that period before 2005, this is a 2004 decision, when under Justice Collins' approach, you could perfectly well have it.
Yeah, I take that.
I think if I understand, they were working on a slightly older definition. If one looks at paragraph 4,
yes.
But it only goes 277 to 295, and their point was that 317 wasn't covered by that more restrictive, or that particular definition, and therefore, whereas
Your Lordship is correct. Of course, my point, I hope, remains that the IAT at that time regarded the idea that one needed one person and one person only to provide the financial assistance was contrary to their understanding and their experience. And there's nothing in the later amendments to suggest that it was the intention of the amendments to remove the possibility of there being more than one person who would provide the financial support. Now, if, as the Court of Appeal found, and if, as I submit, it is permissible to have more than one person acting as the relevant sponsor, the question is whether it is necessary for the joint sponsors to be named as such on the application form. And the majority of the Court of Appeal held that because the granddaughter, Ayan, who was the person who is going to provide the financial assistance, was not named on the form as a joint sponsor, therefore she is not a joint sponsor. Can I remind the Court of where we see that? It's Lord Justice Laws at paragraph 93. It's page 27, my lords, of the appendix. Lord Justice Laws at paragraph 93 points out that Ayan was not named as the sole sponsor. She was not referred to in terms, she was referred to in terms as a source of third-party support. In his Lordship's judgment, the identification of the sponsor by the applicant in the application for entry clearance is of the first importance. The reason is in no sense an appeal to pedantic technicality. It's clear the rules contemplate the possibility of a request being made of the sponsor for a Rule 35 undertaking before entry clearance is granted. Quite apart from an undertaking, it may no doubt be thought necessary or desirable to carry out checks on the standing of the sponsor in this country before the grant of entry clearance. All this, as it seems to me, is inherent in the mechanics of the scheme. It's unworkable unless the ECO and the other authorities are able to rely on the identification of the sponsor put forward by an applicant in his application. Well, the answer to all of that is that provided that the ECO has the relevant information as to who is going to provide the financial support, it matters not whether the correct label has been attached to that person in the application form. And I'll come back to that in a moment. Lord Justice Hill agreed with Lord Justice Laws at paragraph 126. He simply expressed agreement and said it's not a mere technicality. We respectfully invite this court to prefer the reasoning of Lord Justice Carnworth in dissent at paragraph 112 on page 31 of the appendix. I've read the first sentence. He agrees joint sponsorship is permissible in law. That having been accepted, this is paragraph 112, that having been accepted, if it can be shown that the family is in truth able to provide the necessary support, his lordship would regard it as unnecessarily formalistic to hold that the claim should stand or fall on whether they've ticked the right box in the application form. No reason in law or practice in what is designed to be a reasonably benevolent and inquisitorial regime why the system should not be flexible enough for the parties to be helped to get it right, whether before the original decision maker or the tribunal. It's a technical ground. We respectfully invite the court to adopt that approach.
Is His Lordship saying that, for example, the clearance officer might say, well, it would be helpful in your case. We've looked at one sponsor, but you've got this granddaughter and it might actually be helpful if she would agree to be named as a sponsor. Is that the kind of thing?
Yes, what I have in mind, assuming I'm wrong and third-party support is unacceptable, it's only acceptable for there to be a sponsor. The ECO would say to himself that the financial support must be provided by the sponsor or sponsors. There may be more than one. I'm told in this case, which is typical of many, that there is a daughter and a granddaughter. The daughter's going to provide the house, because she's the tenant, but she lives with the granddaughter, and the granddaughter's going to provide the money. The reality of the present case is that the two of them jointly are the sponsors. And if necessary, he would say to the applicants, are you content for me to proceed on that basis? Which is the substance of the case.
The contact details in this case would be the same, actually.
Precisely
the
so.
address is the same, the telephone number and all the rest of it.
Precisely so. I mean, there may be reason on particular facts where that approach is not appropriate. There may be some good reason not to adopt such an approach. But on the facts of this case, which, as I say, are likely to be typical of many, it is formalistic in the extreme to say you filled in the form wrongly, and therefore, if you would otherwise satisfy the rules, you do not do so because you, the granddaughter, have not actually been named as a sponsor on the application form. And that point, if it has force, has even more force in the context that as the ECO agrees, it's paragraph 74 of his printed case, there is no prescribed form for entry clearance anyway. This form is for the convenience of the applicant and no doubt for the convenience of the entry clearance officer. But there is no mandatory requirement for any particular form to be used. And it would have been a valid application for my clients to say to the ECO that the grandmother and the granddaughter wish to join the daughter and her daughter in this country in the circumstances of the daughter owning the house and the granddaughter providing the money. One sees this in MacDonald's immigration law. It's volume 2 of the authorities. If I could ask the court briefly to look at this. Volume 2, it's tab 12. This is an extract of MacDonald on immigration law, and the relevant passage is at page 136, the bottom of the page, under the heading The Application, paragraph 3.17, and on page 137, if the court would pick it up some 8 lines down, it tells us the rules for entry clearance applications, unlike those for variations of leave from persons already in this country, do not prescribe the use of particular forms, so that although the overseas posts all have stocks of standard forms and they're available for downloading, their use is not mandatory. And before HC 395, the case law established that an application for entry clearance did not require any particular formality, merely a request in quite an unambiguous terms for an entry certificate to be issued to a particular person. And then there's a Court of Appeal judgment that an inquiry was not good enough. The rules attempt to overcome the uncertainties of the case law, that is, when is an application made, by saying an application is not made until the fees are paid. And one sees that in the rules that we have at rule number 30. So it's rule 30 that sets out the formality, and the only formality, Rule 30 of Volume 1, Tab 8, page 2800. An application for an entry clearance is not made until any fee required has been paid. And that's it. And it is therefore, in my submission, a very technical argument indeed to say to the appellants that you could be joint sponsors, but you fail because you didn't expressly so describe yourselves in the application form, which is not a mandatory form in any event. That's the submission.
Sorry. Now, I mean, you could have taken, you could have, as my friend Aurora says, I mean, you could have made them joint sponsors and taken undertakings jointly and severally.
Yeah.
And it becomes really rather absurd when you look at the example that MacDonald appears to have in mind at page 137 in the extract of a child wanting to join parents. Why should you be driven to choosing one or other of the parents as the sponsor? I mean, it's immaterial as far as the individual is concerned.
I recognise, of course, there may be reasons in a particular case why the Secretary of State thinks it appropriate to seek an undertaking from both persons or from one or the other. But the Secretary of State, the ECO, perfectly entitled to make that request for the purposes of Rule 35, whether or not the individual has filled in the form correctly. And if I'm wrong in the earlier submission about third-party financial support, it all depends on whether you are a sponsor. That question must be determined in my submission by reference to the merits of the case, the substance of the application, and not a formality that is not even a formality mandated by the rules itself. Again, if the Secretary of State takes a different view and believes that further formality is required before a valid application is made, he is perfectly entitled to amend Rule 30 to add further requirements and put them before Parliament. That would be his prerogative.
Well, when an applicant names, say in this case the daughter as a person, I mean, what does the clearance officer, what do the immigration authorities do? I mean, do they go to that person? How do they know that? How do they know that actually she knows that this is being said and is on the way and so on and so on?
Well, inquiries will be made. I mean,
that's why I'm just trying to. Yeah, they do that. I mean, obviously they mustn't they?
Of course. I mean, if the or evidence would be provided. I mean, they would either go and check, or more usually, evidence would be provided in order to support
some letter or something.
Yes, some letter, or maybe a bank statement showing that money has been paid or money is available. The individual is in regular employment. She has a contract of employment. She's receiving each week a certain amount of money. She would satisfy the entry clearance officer, therefore, that she has sufficient funds to be able to maintain those who are coming here.
And also that she knows that she's...
Oh, absolutely. Yes. Absolutely. Well, the ECO has ample opportunity to check all of
well,
that.
You're asked to give the sponsor's passport number, and yes, you probably wouldn't know that unless you ask the sponsor.
Precisely, sir.
And these details, I suppose, are there just to enable the entry clearance officer to make checks.
Precisely.
And know where to go to get the information.
And they'd have to be living in the same place, wouldn't they? Otherwise you'd be in trouble, wouldn't you, under Roman 4?
Well, again, I mean, the difficulty that would then arise is whether that requires that there must be... there's no suggestion there that the sponsor the two sponsors must be living in the same accommodation. That rule is perfectly open to interpretation, or one of them.
I see.
That would be my submission.
I mean, you've got to be joining them, but I suppose you can join them if they, yes, I
Yeah. It'd be very strange if it wasn't good enough that one lives at number 1 Station Road and the other one lives next door.
Well,
at
I
number
agree,
3
but it'd be
Station
less strange if one lived at number 1 Station Road, London, and the other Station Road, Edinburgh.
It's a more difficult case, I respectfully.
But there's no significance to being, inverted commas, a sponsor unless and until you're asked to give the undertaking. Up until then, you're just somebody who's...
Absolutely. And as I indicated, Your Lordship, even a refusal to give an undertaking doesn't mean that the claim fails. It may do,
Yes.
but then again it may not. I noticed the time.
Sorry, I beg your pardon.
Yes, I was just about to ask whether this was a convenient point at which
Very
to...
much. I won't be much longer.
No. Well, we'll look forward to seeing you at 2
Thank you
o'clock
very
then. Thank you.
Yeah, that's true. That's true. Yeah, I'll come back to that. No, thank you. Doesn't say that it's live. Yeah. Yeah, yeah, yeah.